Welcome back, and thank you for joining us. This PowerPoint presentation and the accompanying narration were designed for East Texas Baptist University for use in the course Criminal Justice 1311, Fundamentals of Criminal Law, and I'm Dr. Eric Hillman. The textbook that we use in this course is Criminal Law, 12th edition by Joel Samaha. This video is designed to supplement the student's reading of the book and not merely to replace it. Chapter 5 is called Justification Defenses. Chapter 5 has been divided into several segments. This is the first of several, so we call this Chapter 5A. As you look at the woman in this picture, a creepy guy is following her. If this guy attacks her, does she have a right to defend herself? Well, we know intuitively that the answer is yes, of course, and that's called self-defense. Self-defense is one of the justification defenses that we will talk about in Chapter 5. Let's review what we mean by criminal liability, and this has been covered in earlier chapters. Criminal liability is conduct that unjustifiably and inexcusably inflicts or threatens substantial harm to individual or public interests. First of all, conduct. We know that all crimes require an actus reus, or an evil act, and that most crimes require a mens rea, or an evil mind. But we have two new words underlined in this chapter, unjustifiably and inexcusably. So we have to figure out what is a justification and what is an excuse. This is Chapter 5, where we talk about justifications. In Chapter 6, we will talk about excuses. However, it's probably worth our while at this point to distinguish between those two. So, the sentence on the screen right now requires you to perform 3 analytical steps. First of all, is there criminal conduct? Was there an actus reus? Was that act voluntary? Was there a required mens rea in order for it to be a crime? Is there criminal conduct? Secondly, is that conduct justified? And again, in this chapter, Chapter 5, we'll talk about justifications. And the third question is that conduct excused? Which we will cover in Chapter 6. So, defenses. This chapter is on justification, and this is a very simple summary of what a justification defense is. When you give in court or to the police a justification defense, you are saying 3 things. First of all, I did it. Secondly, what I did was right. And third, I am responsible for my actions. So look at the picture on the top right corner. This woman is gouging out the eyes of a man. Just that act by itself would be a criminal assault. Should this woman be charged with assaulting the man? Well, obviously it depends on the circumstances. What if this man is trying to rape her? Does she then have a right to defend herself? Yes. Does she have a right to gouge his eyes out? Probably. When the police are called and this man has serious injuries to his eyes, and he says, I want to file charges against that woman for injuring me, and she says, it was self-defense, he was trying to rape me. What is she saying? First of all, she's saying, I did it. Yeah, I did gouge his eyes out. Secondly, she's saying what I did was right. Because it was self-defense, I had a right to defend myself. And thirdly, she's saying, I am responsible for my actions. I made a conscious choice to gouge his eyes out. So, justification. The reason we're putting these three descriptive phrases up is because they're going to differentiate a justification from an excuse. So, self-defense being the most common justification, she's saying all three of these things. I did it. What I did was right. I'm responsible for my actions. Let's look then at excuse defenses. And the most common excuse defense is insanity. I was insane. Now, we're not going to go into extreme detail in this chapter because we're going to cover excuse defenses in Chapter 6. But I'm putting them on the screen now so you can distinguish between justifications and excuses. So let's say that this guy in the bottom picture is insane and he kills someone. If his lawyer says in court, my client was insane and therefore should be found not guilty by reason of insanity, what is he saying? He's saying, I did it. Yes, my client did kill the person. This time, though, he's saying, I was wrong, or my client was wrong. Now, if you look at the top of the page, when you use a justification defense, you're also saying you did it, but in justification, you're saying what I did was right. It was a right for me to defend myself against that rapist. But going down to the bottom half of the screen, and the man who's insane, he also admits that he did it, but this time he's saying, I was wrong to do it. And most importantly, he's saying, I'm not responsible for my actions under these circumstances. So if you use the excuse of insanity, you're saying, I did it, I was wrong to do it, but don't hold me responsible. Why? Because of my mental state. Because of my insanity, I should not be responsible for my actions. So there's three descriptive phrases that distinguish justifications from excuses. So, since this is still Chapter 5, we're going to talk about justifications. If you decide to use a justification defense in court, that is what lawyers call an affirmative defense. What does that mean? There's two stages. Normally, the government or the state or the prosecutor has to prove your guilt beyond a reasonable doubt. That's a very high standard. But if you use justification as an affirmative defense, it means two things. First of all, you, the defendant, the person charged with the crime, have a burden of production to the judge to give some credible evidence. It doesn't have to be a lot, but you have to show some evidence that this was, in fact, a justification, like self-defense. If you give some evidence, just a little bit of evidence to the judge that this was justified, that your actions were a justification, then the judge says, okay, there's some evidence to show that perhaps the defendant was justified in his actions. The judge then sends the issue to the jury to decide whether or not you should be allowed to claim that defense and whether you should be found not guilty because of that defense. So that's the first stage. If you use a justification, you've got to show some evidence to the judge that there really was a justification. Now, you're not having to prove your case to the judge. You're just showing some evidence. Then the judge will send that evidence to the jury. Then you argue your case in front of the jury, where you again, as the defendant, have a burden of persuasion to the jury. But this burden of persuasion is only by a preponderance of the evidence, which means whoever has more than half or more than 50% of the evidence wins. That's often called the 51% rule. So let's look at this again. Normally, you are innocent until proven guilty, and the government, the prosecutor, the district attorney, has to prove your guilt beyond a reasonable doubt. So that's a very high burden on the prosecutor, beyond a reasonable doubt. However, if you decide to say, justification, it was self-defense, then you have to give some evidence to the judge that it could have been justified. When the judge sees that you have some evidence, then the judge will allow the jury to consider the fact that you have a justification defense. When you argue to the jury that you have this defense, you have the burden of persuasion. You have to prove to the jury that you in fact had this justification defense. However, your burden to prove to the jury is lower than the government's burden. The government has to prove your guilt beyond a reasonable doubt. That's a very high level of evidence. 95%, 98%. There's no number associated with it, but it's very high. When you have to prove that you were justified, you only have to prove your case by a preponderance of evidence. In other words, the jury just has to slightly believe you over any other evidence that says you didn't have the justification. 2 steps if you use justification. What if you do use a justification defense? What if that woman was charged with gouging the eyes out of the man and she says, no, he was trying to rape me? Well, the prosecutor has to prove beyond a reasonable doubt, which is a high level of evidence, that she gouged his eyes out. When she says, no, he was trying to rape me, she's saying it was self-defense. So she only has to prove her self-defense, justification, by a preponderance of the evidence, by the 51% rule. When she makes that argument, it goes to the jury, and the jury has to decide. First of all, if the jury believes it's a perfect defense, the jury believes that yes, this man was trying to rape her, and yes, she was fully justified in gouging his eyes out, then she would be acquitted or found not guilty, and she would be allowed to go free. It's also possible that this could be an imperfect defense, meaning the defendant is still guilty of something, but it's a lesser offense. Sometimes in murder cases, a defendant is found not guilty of murder based on evidence, but is still found guilty of manslaughter or criminally negligent homicide. So the jury can find you guilty of a lesser offense. And the third result is that it's simply mitigating circumstances. The jury still finds you guilty of the offense, but takes into consideration the facts of the case and gives you a lesser sentence. So if you're looking at 2 to 20 years in prison, maybe the jury still thinks you are guilty of the offense, but because of the circumstances, they may be more likely to give you 2 years or even give you probation rather than to give you 20 years. So perfect defense, you're not guilty, you go free. Imperfect defense, you're found guilty of a lesser crime. And mitigating circumstances, the jury still thinks you're guilty of the crime charged, but based on the evidence that you showed, they give you a lesser sentence. Types of justification defenses. Self-defense is the most common. Defense of other people, also common. Self-defense, he was trying to rape me. Defense of others, he was trying to rape my friend. That's why I gouged his eyes out. Defense of home or property. The burglar was breaking into my house, so I shot him. Choice of evils. I didn't want to do it, but I had to. I had to do the lesser evil to avoid the greater evil. And we'll talk in some detail about all of these justification defenses. Consent is also a justification defense. All right, let's talk about the first one, self-defense. And as we said before, self-defense is going to be the most common justification defense. First of all, if you're going to claim self-defense, it's got to be an unprovoked attack. The defender didn't start or provoke the attack. So you can't start a fight and then the person fights back and you say, oh, they're fighting me, so I got to defend myself. No, if you start it, you lose your right to self-defense. Imminent danger. If you're claiming self-defense, you've got to convince the jury that you believe the attack was imminent. Imminent is a legal word for immediate. You've got to believe the attack is going to happen right now. So you can't say, well, I was afraid that Joe was going to hit me tomorrow, so I went to his house today and killed him. That's not imminent if you didn't believe the attack wasn't going to happen until tomorrow. Necessity. You must reasonably believe that the force you use is necessary to defend yourself. So if someone pulls a knife and they're about to stab you, you could then pull your gun and shoot them, an armed robber. That's a reasonable amount of force. He's got a deadly weapon, you use a deadly weapon. But if a 5-year-old walks up to you and kicks you in the leg, and you pull your gun and shoot the 5-year-old, that would not be a necessity. It's not reasonably necessary to shoot a 5-year-old to keep him from kicking you. Reasonable force, only that which is necessary. So 3 and 4 are very similar. Only use what force is reasonably necessary. All right, unprovoked attack. Here, this man is sneaking up behind the woman with a knife in his hand. By the way he's holding the knife, it looks like he's about to stab her. So what if she hears him come up, or maybe she sees in the reflection on her computer screen that he's coming up behind her with the knife. So she quickly grabs her gun out of her drawer, turns around and shoots and kills him, or injures him. The initial aggressor is the man with a knife. Since he's the initial aggressor, he can't claim self-defense. So, if this man walks up behind the woman with a knife in his hand, and then he's about to stab her, she turns around, pulls a gun and says, "Leave me alone," he can't then say, "Uh-oh, she's pointing a gun at me, and now I need to use my knife to defend myself." Because he's the initial aggressor, he can't claim self-defense. We also need to discuss the withdrawal exception. If the initial attacker completely withdraws, he can then defend against attack from the initial victim. What does that mean? Well, first of all, this man with the knife is the initial aggressor. We've already established, since he's the aggressor, he can't claim self-defense. However, if she turns around, points a gun at him and says, "Get out of here, or I'm going to shoot you," and he then runs away, he runs and sits in his car, she thinks about it, and she says, "You know what, I ought to shoot him anyway," and she walks out to his car and shoots him. Well, at that point, since he completely withdrew, if she walks out to his car and pulls a gun on him, he then can defend himself against this woman, even though he was the initial attacker. Why? Because he withdrew, he ran away. When we talk about imminent danger, the danger must be right now. You can't say, "I'm going to use force against this person because they might attack me tomorrow." In other words, preemptive strikes beforehand are not allowed. Well, he might break into my house, so I'm going to shoot him today. Well, he might attack my friend tomorrow, so I'm going to shoot him today. None of those work. The danger from which you are facing has to be imminent in order for you to claim self-defense. Also, retaliation after is not allowed. So if someone pulls a knife on you and says, "Give me your wallet," you give him your wallet and he runs away, well, then you have a duty to call the police. If you see the person 3 days later, you can't just pull your gun out and shoot them for what they did 3 days earlier. If you're claiming self-defense, the danger has to be immediate. So let's look at a couple court cases. This one's from 1917 and involves a family, state versus good. The son threatens to shoot the father with a gun. So clearly the son is wrong. This would be assault by threat. Son threatens to shoot father. The father then went to his neighbor's house, said, "Hey, do you mind if I borrow your shotgun?" "Sure, go ahead." "Going hunting?" "Yeah, you bet I'm going hunting." The father borrows a neighbor's gun and comes home. The son sees the father with the gun and he runs away from the father. The father chases him down. The son's running away, trying to get away from dad. Dad's got a gun. The dad catches up with the son. The son then shoots the father. Is that justified? Well, first of all, who's the initial aggressor? The son. So when the son threatened to shoot the father with a gun, if the son had a gun in his hand, the father could turn around and shoot and kill the son because the son's initial aggressor. But here the father went to his neighbor's house, borrowed a gun, and came home, and then the son runs away. So the son has withdrawn. That's the withdrawal exception. The son is running away from dad. Dad chases him down, and then when dad finally catches the son, and dad's got a gun now, then the son shoots the father. That sounds like the withdrawal exception. And in fact, the court said that the son's withdrawal, his running away, meant that his right to self-defense revived. So when the son, in the very beginning, the son threatened to shoot the father was able to use self-defense. However, he didn't use self-defense at that time. Then, later, when the father did have a gun, the son withdrew. The son ran away. The father chased him down. Then the son shot the father. So in this case, the son is claiming self-defense. And the state is saying, wait a minute, you're the initial aggressor. You can't claim self-defense. But the court said, you know what? He withdrew. He ran away. So since he's trying the best he can to avoid this conflict, he now regains his right to self-defense. So the son is not guilty. Necessity is the heart of justification. As a general rule in our society says don't take the law into your own hands, call the police. Why? Because the police are neutral and police can decide differences between family members and between neighbors as a neutral person. The police are not so emotionally involved in the situation. However, sometimes you have to use self-help or self-defense in limited situations because it's absolutely necessary. If someone is chasing you with a gun, you don't have time to call the police and wait 15 minutes for them to get there. So the law recognizes in some situations you have a right to self-defense. That necessity must be great. In other words, if someone is breaking into your house and they have a gun in their hand, that is a great necessity. If you're simply having an argument with your spouse or child, and neither person has a gun, then for you to pull a gun and shoot your child would be really unnecessary. The threat must exist right now, and it can be for prevention only. You can't be the aggressor. When you do use force in self-defense, that force must be reasonable. You can use force to defend against bodily injury. If someone's trying to beat you up, you can use force to stop it. If someone's trying to break your bones or shoot you, you can use reasonable force. And if someone's trying to kill you, they're threatening you with death, you can use reasonable force in self-defense. We've said several times before, but I'll remind you now, whenever we see the word subjective, it means what did you believe? Whenever we see the word objective, we mean what would a reasonable person believe? If something's subjectively reasonable, that means you believed it was reasonable. If something's objectively reasonable, that means a reasonable person in your position would believe it's reasonable. if you claim self-defense, then the force you use must be both subjectively and objectively reasonable. You have to believe it was reasonable, and a reasonable person would have to believe it is reasonable. Let's look at a very famous case from the 1980s, People versus Getz, Bernard Getz in particular, in New York City. New York City, like most cities, has a high crime rate, but in the 1980s, with the crack epidemic, crime was extremely high. Mr. Getz often took the subway. He was robbed and beat up in New York City. He didn't want that to happen again, so he bought a gun for self-protection. Keep in mind that in the 1980s, it was illegal to carry a gun in New York City. After he started carrying a gun, twice people tried to rob him, and twice he scared them away with his gun. One night, Mr. Getz was on the subway, and 4 teenagers got on the subway, and they were carrying screwdrivers. Is a screwdriver a deadly weapon? You bet it is, just like a knife. They cornered Getz on the subway, and they ordered Getz to give them $5. So they're carrying weapons, they're cornering him and ordering him to give them money. That is what we call armed robbery with a deadly weapon. Getz pulls his gun and shoots all 4 of them. Was he justified? Well, self-defense. Was the threat imminent? Yes. Getz used a deadly weapon, a gun. Was that justified? Well, he's outnumbered 4 to 1, and they all have deadly weapons, so it looks like he is justified. So under the rules of self-defense, it looks like he's justified. So these teenagers, all of them shot now, were in the hospital, and a reporter managed to sneak into the hospital and talk to one of the teens. And one of the teens who spoke to the reporter said, yeah, we were there to rob Getz. So they're admitting that they were committing an armed robbery. Getz was charged with attempted murder and illegal possession of a gun. So you have probably a district attorney who is trying to make a name for himself, and he's charged with attempted murder. This is the victim of the armed robbery, charged with attempted murder by shooting the people who were trying to rob him. He's also charged with illegal possession of a gun. The jury found him not guilty of attempted murder. Why would they find him not guilty of attempted murder? Because under the law of self-defense, he's got a right to defend himself. They pulled deadly weapons on him, he shot them. He's clearly not guilty of attempted murder by rules of self-defense, which is a justification. But they did find him guilty of illegal possession of a gun. So New York law says you cannot carry a gun, and yet, although New York can keep you from carrying a gun, New York can't keep you from self-defense. And so Bernard Getz is found guilty of carrying a gun, but not guilty of shooting people with that gun. Kind of an interesting case. History has shown us that whenever you make gun ownership illegal, it will only keep good people from having guns. Bad people, armed robbers, don't care what the law says, so armed robbers are going to carry weapons anyway. So bottom line is, gun control only keeps guns out of the hands of good people, not bad people. The reason we have a Second Amendment is twofold. One, so you can protect yourself against crime, and 2, that you can protect yourself against an overzealous government. So Getz makes the front page of the New York Times, New York Post, makes the front page of Time magazine, and all across the country. People are so tired of crime, especially in the 1980s when crime was so high, that suddenly Bernard Getz became a hero all across the country for shooting these armed robbers. think that kind of backfired on the district attorney. So the jury is required to evaluate Goetz's actions. Do they evaluate his actions by a subjective standard? Do they ask, what did Goetz believe? Or do they evaluate it by an objective standard? What would a reasonable person believe? Judge said both. And here in the comic on the screen, in case you can't read it, the 4 armed robbers are saying, give me $5, and Bernard Goetz is saying, okay, if by dollars you mean gunshot wounds. Well, it's designed to be humorous, but the reality is crime is very common, especially in big cities like New York, and I certainly believe that Mr. Goetz has a Second Amendment right to defend himself. The end of Chapter 5A. This is the first segment of Chapter 5. Once you've viewed this video and taken notes, then I encourage you to continue with Chapter 5B. Thanks and have a great day.